that says interpretation. If you require translation services or a Spanish speaker, please click on the globe and select Spanish as your language of choice, and you will be placed in a room that allows you to listen to the audio of what we are presenting in Spanish. Thank you very much. And now, Heather, if you could please.
Buenas tardes a todo el mundo y gracias por unirse a esta reunión del Departamento de Justicia. Si necesitan interpretación en español, por favor, hagan clic en el globo que se ve en la parte inferior derecha de su pantalla y seleccione español como su idioma de preferencia. Y ya pasarán a la interpretación en español. Gracias.
All right, thank you so much. I will start the translation services now and pass it over to the DOJ team for the presentation.
Good evening. My name is Kristen Clark. I am the Assistant Attorney General for the Civil Rights Division of the U.S. Department of Justice. We thank you for joining us today. 3 years ago, the deaths of Breonna Taylor and George Floyd galvanized communities across our country, communities that were calling for constitutional policing and respect for people's civil rights. We saw people across the country coming together to demand that leaders take action, that police departments ensure accountability, and that cities institute the reforms needed to ensure public safety while restoring public trust. And at the heart of the demonstrations that we saw across the country, again, was a call for and demand for constitutional policing and respect for people's civil rights. And that's what we fight for each and every day inside the Civil Rights Division of the U.S. Department of Justice. We are here today because we have published our findings regarding the Louisville Metro Police Department. We opened an investigation in April of 2021, and our efforts to uncover problems inside the department were extensive and comprehensive. The team that you see assembled here and dozens of others inside the Justice Department conducted on-site tours, ride-alongs with officers, reviewed thousands of documents, policies, training material, body cam footage, and more. We engaged with the community. We listened to the community and took in information and input about people's experiences with the Louisville Metro Police Department. All of that work has culminated in an extensive 90-page findings report that lays bare significant concerns with the police department. We uncovered in brief that the police department uses excessive force, and that includes unjustified neck restraints and the unreasonable use of police dogs and tasers. We found that the police department conducts searches without valid warrants. We found that the police department unlawfully carries out and executes search warrants without knocking and announcing. We found that detain and arrest people during street enforcement activities, and that includes traffic stops and pedestrian stops. We looked at a range of police enforcement activities and found that the department unlawfully discriminates against Black people. We found that the department also violates the First Amendment rights of people engaged in peaceful demonstrations and protests, particularly when people were engaged in speech that is critical of policing. We also found that the police department and city discriminate against people with behavioral health disabilities when responding to them in crisis. And I will note that our finding here under the Americans with Disabilities Act marks the very first time that the Civil Rights Division has issued a finding with respect to how the city dispatches a response to people experiencing behavioral health crises. In addition, we identified significant concerns with respect to how the police department handles investigations into sexual assaults and complaints of domestic violence. Today marks a new day. Today, with the commitment of the mayor and the commitment of the police chief, we have announced that we will institute a consent decree to address the findings that the Justice Department has uncovered here. That consent decree, once negotiated and finalized, will be entered before a federal court. It is a consent decree that will come with judicial oversight. That consent decree will also call for an independent monitor who will help ensure that the reforms that are instituted are lasting and successful. I have assembled here today a number of people who worked on this very important investigation. The purpose of this meeting is to provide further detail on our findings. In the road ahead, we look forward to engaging with you. Continued input and engagement from the public will be critical to ensuring the success of our efforts. At the end of this process, we hope that we have a city and a police department where there is constitutional, fair, and non-discriminatory policing. The people of Louisville deserve nothing less. At the end of this process, we hope that we have a police department that might serve as a model for other law enforcement agencies across our country that are in need of reform. This work is incredibly important. It is one of our highest responsibilities. I am pleased that Attorney General Garland and Associate Attorney General Gupta joined for this important and historic announcement today. We are all ready to get to work. We are all ready to serve the people of Louisville who deserve constitutional policing and nothing less. I'm going to now turn the floor over to my colleague, Paul Killebrew, who will provide further detail on our findings report.
Thank you, Assistant Attorney General Clark. Everyone, thank you so much for joining us tonight. We know that this is a meeting that we inform the public about at the last minute, and we know that people may have rearranged their schedules to hear what we have to say tonight, and we deeply value all of your participation and hearing what we have to offer. As Assistant Attorney General Clark noted, we completed our investigation of Louisville Metro and LMPD. I want to give a little bit of background about that investigation, and then I'm going to ask the members of our team who investigated the various issues that are covered in our findings report to give you a little detail about what that report says. So the team who did this investigation is made up of career attorneys, investigators, paralegals from both the Civil Rights Division of the United States Department of Justice, and that's located in Washington, D.C., and also the Civil Division of the U.S. Attorney's Office for the Western District of Kentucky, which is in Louisville. So there were people from Washington participating and people locally in Louisville on the investigation. We were assisted by over a dozen experts from a bunch of different areas, former law enforcement, retired law enforcement folks, a retired FBI agent, a retired federal judge, people with expertise in behavioral health, people with expertise in a host of different areas that are covered by our investigation. We went on site in Louisville numerous times during the investigation. We spoke to residents from across the city. We spoke to community groups. We spoke to individuals who had had encounters with the police, people who had had good experiences and bad. We spoke to organizations that are doing everything they can to make Louisville a safer place for everyone. We spoke to community activists, criminal defense lawyers, prosecutors, judges, and service providers throughout the city. With Louisville's cooperation, we visited every single patrol division in LMPD and its specialized investigative units, other specialized units. We spoke to supervisors, we spoke to the leadership, we spoke to many, many patrol officers. We also interviewed Louisville Metro officials, people not in the police department, but who have responsibilities in public safety, including people like call takers who take 911 calls, dispatchers, and their supervisors. we reviewed thousands of documents, policies, trainings, incident reports, investigative files. We reviewed data on tens of thousands of law enforcement encounters. And we analyzed and watched thousands of hours of video from body-worn cameras. All of that to say that the findings that we're going to talk to you about in a moment are not based on any one incident or one event. They're based on the review of a number of incidents over a number of years to try to evaluate whether there are systemic problems at the Louisville Metro Police Department and Louisville Metro Government. So, as I said before, I'm going to turn it over to the team to cover each area of the investigation. But before I do that, I want to draw everyone's attention to something that's at the end of the report. At the end of the report, there's a section called Recommended Remedial Measures. And those measures are there to set out a blueprint of what we think needs to happen next, the change that needs to happen going forward. And so I would ask members of the public to take a look at that, to see the ideas that we have for making improvements down the road, because we need to know your ideas for reform. We need to get input from the public. If there's something that we didn't get right in those recommended remedial measures, we want you to tell us. If there's something that we missed, we need to know. And so, because we're going to use these conversations that we're having with folks as the framework for the consent decree that Assistant Attorney General Clark mentioned. The consent decree will be the roadmap to reform, and it will provide detailed remedies for the issues that we're going to talk about tonight. And we want to get that document right. To get it right, we need your help. So with that, I would now like to turn this over to the members of our team to go through our findings issue by issue. We'd like to start with Maveen Riaz, who's a trial attorney in the Civil Rights Division, and she's going to talk about the issues that we found with regard to excessive force. Maveen?
Thank you, Paul. I want to also mention that today is really an opportunity for us to summarize our findings for you. There'll be opportunities in later meetings where we can have a more interactive approach. And as a result, we're not going to be answering the questions in the chat, but we will keep note of them, and we encourage you to submit them through our community inbox and our phone number, which we will put in the chat. So with that, I'd like to start, as Paul said, to discuss our finding on excessive force. So we have reasonable cause to believe that LMPD uses excessive force in violation of the Fourth Amendment. Paul touched on our investigative process broadly, but with regard to our excessive force claim, we reviewed a sample of less lethal or non-deadly force incidents for which supervisors submitted a use of force report. And we looked at the years 2016 through 2021. And our review included watching footage of the incidents from body-worn cameras. We also reviewed all closed internal LMPD investigations that were classified as officer-involved shootings from 2016 to 2021. We also looked at LMPD policy and training materials related to use of force. And we interviewed LMPD officers and supervisors, as well as members of the public who've experienced or witnessed encounters involving force by LMPD officers. And throughout all of this, we were assisted by our law enforcement experts. So as a result of this review, we found LMPD's use of unreasonable force to be widespread and to extend to both deadly and non-deadly uses of force. In terms of big picture themes across the problematic uses of force, we found that officers use force that was not warranted or justified under the law. For example, officers use force simply because people don't immediately follow their orders, even if those people aren't physically resisting or posing a threat to anyone. Officers also use force to punish or retaliate against people that are challenging their authority. They've also used unreasonable force against peaceful protesters, people with disabilities, and teenagers. And finally, officers not only fail to de-escalate, but they actually escalate situations they encounter. And this leads to uses of force, deadly and non-deadly, that are unwarranted or disproportionate under the circumstances. I also want to drill down to the specific types of problematic uses of force. We found that officers use neck restraints, such as chokeholds, in ways that violate the Constitution, such as using them against people who are not resisting or people who have already been handcuffed or otherwise subdued. Officers deploy police dogs against people who pose no threat to them or who are trying to comply actually with officer commands. And we also found that LMPD officers allow their dogs to continue biting people even after they're surrendered. Officers also deploy tasers against people who aren't physically resisting or attempting to flee, and against people who are already restrained or otherwise submitted to the officer's authority. And we saw instances where officers tase people multiple times without justification and intentionally target vulnerable parts of people's bodies. Finally, officers use takedowns, strikes, and other bodily force in ways that are unnecessary and unlawful. Part of our investigation also sought to evaluate the root causes of the deficiencies that we're identifying. And we looked at, as I said, foundational materials such as force-related policies and trainings, and evaluating LMPD's accountability systems. And this included looking at frontline supervisor responses all the way through LMPD's internal affairs units. We found that LMPD's policies and training fail to provide officers clear guidance on how and when it is appropriate to use force, and how to choose among the various force options available to them. We also found that LMPD fails to properly investigate uses of force, and that it does not address potentially unreasonable force and remedy bad tactics when they occur. So this is in a nutshell our excessive force findings. Obviously, the report lays out in much greater detail the scope of our findings. I'd like to now turn it over to my colleague, Jessica Malloy, who is an assistant United States attorney here in Louisville, to discuss our findings about search warrants. Jess?
Thank you, Maybeen. The first aspect of our findings involving search warrants is the applications themselves. We found reasonable cause to believe that LMPD engages in a pattern or practice of seeking search warrants in ways that do deprive individuals of their rights under the Fourth Amendment. To reach this finding, we reviewed a sample of LMPD's warrant applications. The sample was from January 1st, 2016 through October 31st, 2021. We examined information from more than 1,800 suppression hearings, reviewed, again, LMPD's training, guidance, procedures related to warrants, and interviewed officers. We spoke with community members. We spoke with stakeholders. In doing this, we learned that 40% of LMPD's applications relate to narcotics. More than 35% relate to LMPD's major crimes units. That means homicide, robbery, crimes against children, and special victims. And about 17% of the applications are from the patrol divisions, the individuals, the detectives that are in your neighborhoods. After we made the determination of where these applications were coming from, we started looking at the details inside the applications. That's where we learned that the applications frequently lack the specificity and the detail that is necessary in order to establish probable cause for the search. We found that the applications were typically overly broad in scope, that they failed to establish probable cause for searching everything and everyone that was listed on the warrant. Now, another issue is officers' use of confidential informants. These informants were used in more than a third of the search warrant applications in our sample. All of those applications were narcotics related. This investigation revealed that many of those applications lacked probable cause. Now, that's often because the warrant application itself included little to absolutely no information to explain why that confidential informant who provided information was reliable, or they failed to explain what information the confidential informant provided or how many informants LMPD used to gather that information. We also found that this routine failure by LMPD to demonstrate probable cause in search warrant applications, it's the result of poor supervision. It's also the result of poor oversight within the agency. The errors in these applications were enabled, they went uncorrected, and they were consistent. We also found that although Jefferson County has a rotating schedule for judges to review warrant applications, LMPD does not follow the court schedule. Of the warrants in our sample, officers rarely sought approval from 19 of the 30 judges. Just 6 of the judges alone approved more than half of the warrants in our sample. LMPD also submits approximately 25% of search warrant applications under seal. Now, sealing warrant applications and other court documents is often necessary in order to protect the integrity of criminal investigations, the identity of confidential informants, or other legitimate law enforcement interests. But LMPD officers seal search warrant applications and keep them sealed when these interests are not or are no longer at stake. Now, perhaps owing to this lack of transparency and availability of outside scrutiny, we found that the rate of problematic probable cause justification in sealed applications was 3 times the rate of unsealed applications. We also have a finding about warrant executions. When LMPD conducts searches of people's homes based on these search warrants, we found reasonable cause to believe that LMPD engages in a pattern or practice of executing warrants in violation of the Fourth Amendment. Specifically, in executing search warrants on private homes, LMPD officers regularly fail to knock and announce their presence. Officers also execute warrants at unnecessarily late times. They routinely fail to record the warrant executions using their body-worn cameras, and they routinely fail to conduct risk assessments. And those are used to evaluate the safety and necessity of each particular warrant execution. To make this finding, we again reviewed LMPD's internal documentation. We reviewed their documents assessing the risks involved in executing a warrant. We reviewed LMPD's records describing warrant executions and identifying what's called exigent needs to execute without knocking and announcing. We also reviewed supervisory reports, the ones related to warrant executions, and watched many videos of LMPD officers executing warrants. Now, importantly, there were only 10% of the residential search warrants in our sample that we pulled that were captured on body-worn camera. Because of that, we had to comb through all of LMPD's internal records and audit LMPD's video database to identify videos of warrant executions on residents, again, from January 2016 through October 21. Now, LMPD rarely, and that's just 2.5% of the time, requested judicial authorization to execute a warrant without knocking and announcing. Now, that's during the time period before the city passed laws saying it's not allowed and before the state. So before, when LMPD could ask a judge to issue a warrant saying they didn't have to knock and announce, LMP only did that 2.5% of the time. Nevertheless, LMPD officers still entered homes without knocking and announcing in more than half of the warrant executions we reviewed. They did so even though LMPD's policies at the time required them to knock and announce. In more than a third of our sample, LMPD served warrants at night unnecessarily without taking appropriate measures to ensure public safety. In the federal system, courts must approve executing warrants at night, and there has to be a specific reason for doing so. It's a dangerous practice. It puts officers at risk of being misidentified as intruders, and officers are put in a position where they can misinterpret the shock and surprise of residents as a threat. LMPD officers also routinely fail to conduct risk assessments. Now, the policy at LMPD requires that officers who are proposing executing a search warrant, that they evaluate the risks of doing so according to that risk assessment matrix. The matrix itself identifies factors that can make a warrant execution more or less dangerous, and it boils those factors down into a numerical score. It's a crucial tool for supervisors who evaluate proposed warrant executions. And across the country, police departments use matrices like this to protect officers and to protect the public. But LMPD officers do not complete these matrices and put everyone at risk. Supervision is lacking when it comes to executing these search warrants. LMPD policy requires supervisors to review and write reports about certain warrant executions, but their reports are rarely meaningful. Rather than individually assessing officers' actions, supervisors write the same sentence over and over. Moreover, supervisors do not complete their reviews in a timely manner, do not say whether they watched the body-worn camera videos or whether officers failed to record the execution. And they don't identify even every officer who was present, much less describe their roles during the search warrant's execution. With that, I'm going to turn this over to Dave Cooper, who is a trial attorney in the Special Litigation section in the Civil Rights Division. He's going to talk about LMPD's straight enforcement activities.
Thank you, Jess. We found in our investigation that LMPD engages in a pattern or practice of street enforcement that violates the Fourth Amendment. We found these violations in stops, frisks, detentions, searches, and arrests involving both pedestrians and people in cars. Our findings are based on a number of different types of evidence. We interviewed LMPD officers and supervisors. We went on ride-alongs with officers, where we joined them on routine patrols. We reviewed LMPD training materials. We selected a random sample of the thousands of traffic stops conducted by LMPD from 2016 to 2021 that resulted in a citation or an arrest. For those stops that we selected, we looked to see if there was evidence of constitutional violations in the reports filed by officers after the stop and by watching footage from officers' body-worn cameras. We reviewed dozens of internal affairs investigations and court cases involving stop searches or arrests by LMPD officers. And finally, we interviewed many community members about their experiences during traffic and pedestrian stops. And we spoke with people who work in the criminal justice system, including prosecutors, criminal defense attorneys, and judges. Based on this evidence, we concluded that LMPD routinely violates the Fourth Amendment. Officers frequently stop and frisk people without reasonable suspicion that the person has been involved in a crime. During traffic stops, officers reflexively frisk drivers and passengers, even when there's no reason to believe they are armed and dangerous. Officers coerce people into consenting to be searched instead of obtaining consent voluntarily. Also, during traffic stops, officers search cars without probable cause and unreasonably detain people for longer than necessary. Officers have unlawfully searched and seized the belongings of people experiencing homelessness and have unlawfully searched homes without warrants. We found officers unlawfully arrest people. For example, they have arrested people for participating in protests, which are protected by the First Amendment. And they have arrested people for crimes like disorderly conduct or menacing without evidence establishing that the person committed the crime. These violations reflect an overly aggressive approach to street encounters by officers. Officers' actions often violate LMPD's own policies as well as the Constitution. But LMPD's training materials encourage this aggressive approach to stops. In addition, LMPD supervisors do not regularly review their officers' stops, searches, and arrests to ensure they are compliant with policy and the law. One unit in particular exemplified this aggressive approach, the 9th Mobile Division, which was originally called the Viper Unit and has now been renamed and merged into the Criminal Interdiction Division. However, this was not the only place where we found problems. We found violations across all of LMPD's patrol units. Unlawful street encounters like these can be invasive and humiliating, and they undermine public safety by poisoning the relationship between the police and community members. I will now turn to my colleague Suraj Kumar, who is also a trial attorney in the Special Litigation section of the Civil Rights Division, and he will discuss our findings on racial discrimination at LMPD.
Thanks, Dave. In our investigation, we looked at whether LMPD engages in discriminatory policing based on race. We found reasonable cause to believe that LMPD unlawfully discriminates against Black people in its enforcement activities. That conclusion is based on the following evidence. First, we found large racial disparities across a range of LMPD's enforcement actions, including stops, searches, and arrests. In multiple areas, LMPD treats Black people differently from white people who engage in similar behavior. LMPD disproportionately stops and cites Black drivers for minor traffic offenses, like equipment violations. For example, Black drivers were nearly twice as likely as white drivers to be cited for having one headlight out, almost 4 times as likely to be cited for improperly tinted windows, and nearly 5 times as likely to be cited for improper tags. Another example is LMPD's marijuana enforcement. Now, public health data shows that Black people and white people use marijuana at similar rates. But when we looked at LMPD's citations and arrests arising from traffic stops, we found that LMPD cites or arrests Black people for marijuana possession at nearly 4 times the rate of white people. LMPD also detains Black drivers during traffic stops for longer periods of time than white drivers who were stopped for similar reasons. And LMPD disproportionately enforces certain misdemeanor offenses against Black people, like loitering and disorderly conduct. Importantly, our analysis understates the actual racial disparities in LMPD's enforcement because LMPD has failed to document thousands of police encounters in Black neighborhoods. But our analysis is not the only evidence of LMPD's unlawful racial discrimination. In fact, LMPD's own analyses and other reports over 2 decades show that its traffic enforcement practices disproportionately affected Black people. But LMPD has maintained those practices for years. For example, LMPD has pressured officers and supervisors to generate stats like stops and arrests, especially in predominantly Black neighborhoods. And as I mentioned earlier, LMPD fails to collect enough data on officers' activities, like traffic stops and pedestrian stops. The third category of evidence that supports our finding of racial discrimination is that LMPD fails to respond appropriately to officers who express explicit racial bias and animus towards Black people. In our findings report, we describe instances of some officers displaying racial bias, disrespect, and contempt towards Louisville residents. But from 2016 through 2022, LMPD did not discipline a single officer for biased law enforcement practices or racial prejudice. LMPD's inadequate response to racial bias signals that discrimination is tolerated. It deepens community distrust, and it undermines the many officers who try to do their jobs fairly and impartially. Now, LMPD's discriminatory policing practices are not only unlawful, they've also been counterproductive. LMPD has relied heavily on pretextual traffic stops in Black neighborhoods, often for minor traffic offenses. But studies from across the country have found that relying on pretextual stops can lead to racial disparities without meaningfully improving public safety. Unnecessary and intrusive traffic stops also erode community trust, which undermines efforts to solve violent crime. From 2016 to 2021, LMPD only arrested a suspect in 1 out of every 3 homicides in Louisville. And when a homicide victim was Black, LMPD was 33% less likely to arrest a suspect than if the victim was white. One LMPD leader told us that when the police make pretextual stops in what they call hotspot neighborhoods, the residents of those neighborhoods are targeted twice, first by violent crime and then by the police. LMPD is not the only city agency that plays a role in public safety. Other agencies provide important services like violence prevention, behavioral health services, and programs for youth. But Louisville Metro has not sustained investments in those services. In fact, police officers told us that they're asked to be social workers or mental health professionals, and they need more support from the rest of city government. Addressing LMPD's discriminatory policing will require significant changes in LMPD. It will require continued engagement from community members, and it will require support from other parts of Metro government. Louisville Metro and LMPD must implement and sustain practices that reduce discrimination and keep people safe. Now, my colleague Jared Hager, a trial attorney in the Special Litigation section of the Civil Rights Division, will discuss our First Amendment findings.
Thank you, Suraj. We have reasonable cause to believe that LMPD engages in a pattern or practice of conduct of retaliating against protected speech that is critical of police in violation of the First Amendment. Our findings are based on 4 categories of evidence. First, we looked at a lot of LMPD documents, including documents related to protest policy, procedures, their training, arrest citations, the planning documents that they prepare before a protest event, the review documents that they prepare after a protest event. We looked at their use of force reports and their supervisory review of those force reports related to protest events. And we looked at civil rights lawsuits, press reports, and other related documents. We also relied on a lot of video, thousands of hours of video that came from the chest of officers on their body-worn cameras, that came from credentialed media that recorded protest events as they happened, and to the credit of the Louisville community, a lot of civilian live-streamed video of protest events. We also relied on a lot of interviews. We interviewed scores of people, including LMPD officers, LMPD leadership, elected leaders of Louisville Metro Council, civilians who attended protests like you, including members of the clergy, members of the press, live streamers, and others. These are parents, children who attended these protest events. Finally, we relied on the expert opinions of folks in law enforcement and statistical experts. What we found is that LMPD often violates the First Amendment rights of people who protest against police action. Now, during the racial justice protests of 2020, we saw LMPD officers sometimes use riot sticks, less lethal munitions like pepper spray and rubber bullets, pepper balls. We also saw chemical agents be used, sometimes indiscriminately, sweeping in both folks who were suspected of criminal conduct and innocent, law-abiding people who were expressing their First Amendment right to protest against police action. We also saw LMPD improperly arrest peaceful and lawful protesters, sometimes for only dispersing slower than LMPD officers wanted, or for passively resisting LMPD officer commands. The First Amendment does not tolerate such conduct, and it has a great propensity to chill others from either engaging in such protected speech or assembling with others who want to engage in such protected speech. But our findings aren't limited to the 2020 racial justice protests. Both before and after, in both large groups and in individual encounters with individuals who wanted to criticize police, we saw LMPD officers engage in similar retaliatory practices against lawful, merely verbal challenges to police action. We traced this pattern or practice of unconstitutional conduct to various deficiencies in policies, in training, in planning, and in after-action reviews. Now, I would like to turn to Haley Van Aram, a trial attorney in the special litigation section, who will talk a little bit more about our findings under the Americans with Disabilities Act.
Thank you, Jared. We found that Louisville Metro Government and LMPD violate the Americans with Disabilities Act, or the ADA, in their response to people with behavioral health disabilities. Those are disabilities such as mental illness or substance use disorder. When people are experiencing behavioral health episodes or crises, Louisville Metro Government and LMPD have subjected many of those people to an LMPD response that was unnecessary. In determining Metro's and LMPD's compliance with the ADA, we worked with experts in the areas of behavioral health services, crisis response, and dispatching. We analyzed documentation from a random sample of 911 calls. We also reviewed audio recordings of 911 calls, camera footage of police encounters with people with behavioral health disabilities, and LMPD's policies and training practices. We interviewed Metro officials, LMPD officers and supervisors, behavioral health providers, people with behavioral health disabilities and their families, and other community members. And we found that in Louisville, LMPD officers are the primary and generally the only responders to situations involving behavioral health issues in Louisville, even where safety does not require the police. Many incidents we reviewed could be safely and more effectively resolved through a response by behavioral health professionals, such as a mobile crisis team, without law enforcement at all. Others could be resolved with co-responding behavioral health professionals, along with appropriately selected and trained officers. We also found that unnecessary LMPD response to people with behavioral health disabilities is often ineffective and harmful. LMPD officers frequently fail to de-escalate situations involving behavioral health issues. We saw that officers often crowd people in crisis, rush the situation, and shout orders at people in crisis rather than speaking calmly. Officers' behavior was ineffective, and it increased the risk to themselves and to the person in crisis, and at times it created the entire crisis and made it much worse. We also saw videos of LMPD officers insulting and mocking people with disabilities. In many instances we reviewed, LMPD actions led to the uses of force and arrests that were avoidable. In fact, nearly 1/4 of all of the uses of force we reviewed involved people who appeared to be experiencing behavioral health crisis. These unnecessary or overly aggressive LMPD responses violate the Americans with Disabilities Act. We also found that Louisville Metro can take steps to avoid this discrimination against people with behavioral health disabilities. These steps include deploying non-law enforcement responses. Louisville Metro has already begun doing this through its crisis call diversion program on a limited basis, and Louisville could expand that program and deploy non-law enforcement responses wherever appropriate. Our interviews with stakeholders, including officers, Metro government officials, behavioral health service providers, and community members, all showed agreement that an alternative response could be effective and safe in many situations. Louisville Metro could also enhance coordination with Louisville's crisis hotline and other behavioral health services. And LMPD can make changes to their crisis intervention program to avoid the discrimination against people with behavioral health disabilities. So I'll now turn it to Amy Senior, another trial attorney in the special litigation section, to discuss the issues that we identified with investigations of sexual assault, sexual misconduct, and domestic violence.
Thank you, Haley. We have serious concerns about how LMPD responds to and investigates reports of sexual assault and domestic violence, including reports of sexual misconduct and domestic violence by LMPD officers. Let me tell you a little bit about what we did to investigate this issue. We reviewed nearly all of LMPD's closed criminal and administrative investigations into reports of sexual misconduct and domestic violence by LMPD officers from 2016 to 2020. We also reviewed a sample of LMPD body-worn camera videos from 2020 to 2021 and investigative files for adult sex crimes and domestic violence reports within the Louisville community from 2018 to 2021. We reviewed LMPD policies and trainings on responding to sexual assault and domestic violence, and we interviewed survivors of sexual assault and domestic violence, advocates, prosecutors, and LMPD officers, detectives, and supervisors. We were helped in our review by 3 law enforcement experts with specialized expertise in conducting sexual assault and domestic violence investigations. In our review, we saw many of the same repeated deficiencies, including many of LMPD's investigative case files were in a poor state. They were missing expected materials and documentation. LMPD failed to identify, maintain, and adequately analyze all relevant evidence, particularly non-DNA evidence such as text messages, photos, and physical evidence. LMPD did not consistently interview suspects and witnesses. LMPD did not consistently use victim services to assist victims during investigations. In domestic violence cases, LMPD did not always conduct lethality screenings into the dangers facing victims, even when policy required it. And we saw examples of LMPD officers relying on sex stereotypes, such as skepticism, when responding to calls about sexual assault and domestic violence. Among the several causes for these concerns, we noted cuts to LMPD's domestic violence squad and staffing shortages in its Office of Sexual and Physical Abuse Investigations that compromised detectives' ability to adequately investigate these serious crimes. These cuts corresponded to increased caseloads for both units and changes to case outcomes, such as closing domestic violence cases by sending many victims a letter rather than conducting a full investigation. I will now turn it back to Dave Cooper, who will discuss the issues we saw with supervision and accountability.
Thanks, Amy. As part of our investigation, we tried to uncover the root causes of the types of violations that you've just heard us describe. We found failures in LMPD's supervision and accountability systems that we believe are a significant cause of these violations. Starting from the training academy, going through to frontline supervision, and ultimately internal affairs, we found failures. LMPD's training academy has not assessed officers' training needs, overseen training for specialized units, or developed consistently high-quality training that includes scenario-based lessons and other teaching techniques that are most effective for adult learning. Supervisors at LMPD regularly fail to identify problematic conduct by the officers they supervise and to document and address that conduct. This results from a widespread reluctance among supervisors to confront their officers about violations of policy, as well as from inadequate training for the supervisors themselves. Furthermore, we found flaws at each stage of LMPD's process for investigating complaints of officer misconduct. LMPD sets arbitrarily high thresholds for investigating allegations, and when they do investigate, the internal affairs units regularly fail to conduct investigations that are thorough, fair, and prompt. Meanwhile, the disciplinary decisions that follow misconduct investigations often depart from the investigative findings without adequate documentation. All of this means that officers do not face meaningful consequences for problematic conduct. Some officers have engaged in repeated violations without facing discipline. Louisville Metro's creation of a new Inspector General and Civilian Review and Accountability Board is a positive step. But the completion of an MOU with LMPD, which they are currently negotiating, will be necessary for them to carry out their duties. And when they make findings and recommendations, it will be up to LMPD to take action in response. I'll now turn it back to Paul Killebrew to discuss our recommended remedial measures and close us out.
Thanks so much, Dave, and thank you to the entire team for giving us such a detailed look at the findings that we announced today about Louisville Metro Government and the Louisville Metro Police Department. And thank you all who are watching this for taking some time out of your evening to hear about this. I hope you will read the entire report. I know it's not a short read at 90 pages, but we took great care to ensure that we told the full story of what was happening in Louisville Metro and the police department. So what comes next? That's the question. And I just want to sort of reflect for a moment that reaching the findings of this investigation and releasing this report is really just setting the groundwork for the changes that need to come. This is just to establish the record of problems so that we can start figuring out what the appropriate solutions are. I'm going to go through some of the areas that are covered at the end of the report. As I mentioned at the very beginning of this meeting, the report ends with this section called Recommended Remedial Measures. And it includes point by point some things that we think need to be done at LMPD to address the findings that we announced today. So I'm going to march through some of those issues, and they are linked up to the things that you heard about from each member of the team tonight. But to give you a kind of overall framework, what police departments need to do to bring their practices into compliance with the law, they need to have policies that instruct officers about what the expectations are. The policies set the rules of engagement. They tell officers what's allowed and what's not. They need to be clear. They need to be understandable, and they need to provide a framework for officers to know right from wrong within the department. They also need to reflect the community's values and, of course, all legal requirements. Policy, huge component of reform. Next is training. Training is a piece, it has to provide officers with, it has to translate the policies into their day-to-day actions. So training is how we educate everyone within a police department about the expectations of the department. And so high quality training that is appropriate for adult learners is really necessary within a police department if you expect those policies to mean anything to police officers day by day. So you have policies and you have training. Well, what comes next is supervision. So the police officers are going about their jobs. Their supervisor needs to ensure that the officers are conducting themselves consistently with the policies of the department and the training that they've received. And that supervision needs to reinforce rather than undermine policies and training. If supervision is undermining policies and training, you might as well not have them at all. So quality supervision is a key component. Okay, so the last major key component is accountability. What happens when somebody violates a policy? It has to be that the department holds those folks accountable. That might mean discipline, it might mean coaching, it might mean a lot of different things, but the department has to note when misconduct occurs, when somebody does something that's not consistent with policies and training, and then they have to act. They have to ensure that that is looked into. It may need to be investigated. And yes, sometimes the officer may need to be disciplined. If you have good policies and good training and good supervision, but you have a failed accountability system, those first three components will not produce meaningful change. So as I march through the issues that we've talked about tonight, that is the general framework that we look for within a police department to achieve reform. So just going through the issues that we discussed. When it comes to use of force, the Louisville Metro Police Department needs a complete change in how they handle use of force incidents when they occur. When it occurs, officers must report it. We found incidents of unreported force. That has to stop. When it's reported, supervisors or others need to investigate what happened and determine whether or not the force complied with policy. Officers need to turn on their body cameras, because if there's not a recording of the incident, there's not a good enough record to work with. And so officers, if they're not turning on their body cameras, that needs to be addressed. When it comes to search warrants, the department has to improve its process for investigations and writing up search warrants to ensure that the warrants actually establish probable cause for each thing to be searched. There's a lot of internal process that can be developed within LMPD to ensure that that happens. When warrants are executed, again, those body cameras have to go on, and officers have to follow the constitutional limits around knocking and announcing their presence. And they can't be doing these things at night without a really good reason. When it comes to street enforcement activities, officers need clear rules of the road around when they can stop, frisk, detain, and search people. It was clear to us through our investigation that officers do not know what the Fourth Amendment requires too often. And so that they certainly need better policies and training and supervision around all of those issues. When it comes to racial discrimination, a key component here is going to be the collection and analysis of data on an ongoing basis to see the impact of different policing strategies on different communities within Louisville, and making changes to how policing is done to ensure that there are not unlawful impacts. Also, Louisville needs to reconsider the role of proactive street enforcement that focuses on pretext stops and Black neighborhoods. When it comes to protests and demonstrations, there just needs to be a new system for how LMPD prepares for protests and demonstrations, how they supervise during the course of protests and demonstrations, and after it's over, how are they learning from protests and demonstrations to ensure that on an ongoing basis, people are able to express their First Amendment rights. There also needs to be training for officers on how to control themselves when people are protesting against the police. It's understandable that that can be an escalating feeling for officers, but it is something that people have a constitutional right to do. So we have to figure out how to make that happen lawfully. And then when it comes to the Americans with Disabilities Act violations that Haley talked about, she mentioned there's already a pilot program going for mobile crisis response where people who are not police officers are responding to people with behavioral health disabilities. That needs to be expanded. And we need to look at other options as well. Perhaps there could be, if the call is too dangerous to not have a police officer there, well, maybe a mental health professional can join the police officer on the call. And sometimes there has to be a police officer there. Well, let's make sure that that police officer actually has the training and capabilities that are necessary to handle those things effectively. When it comes to sexual assault, domestic violence, and sexual misconduct investigations, those must be improved. There must be appropriate staffing levels to handle the workloads of those units. And as my colleague, Mr. Cooper, mentioned, accountability systems just absolutely have to be improved, along with civilian oversight. When misconduct occurs, it has to be identified, investigated in a timely manner, and officers have to be held accountable in fair and consistent ways. Finally, the Louisville Metro Police Department needs to set its own officers up for success. Now, some of that is the policies and training and supervision that I talked about before, but it's also looking into their health and wellness. They have difficult jobs and they need to get the support that they need. So all of that is really just the starting point. We are going to use the points that we've outlined here to put together a framework for a full consent decree That consent decree is going to be aimed at improving public safety. It's going to be aimed at improving officer safety. And most importantly, it's going to be aimed at eliminating the pattern or practice of violations that we identified and promoting constitutional and effective policing in Louisville. So again, we want to hear from members of the public, from members of the community, people who have been impacted by police misconduct, people who have had encounters with the police, be they good or bad. We have put the 800 number and email address into the chat. We encourage you to reach out to us. As I said before, this findings report, it's a lot to take in, but honestly, it is really now that we can start to work on solutions. And the solutions are really where the rubber hits the road in this reform process. We want to negotiate an effective consent decree that puts us on the pathway to a safer Louisville, and we need your help to get that right. So again, we thank all of you for coming to this Zoom meeting on such short notice. I'm sure people rearranged their schedules to be here. We very much appreciate it. And with that, I will say thank you and good night.